Okay, let's dive right into this explainer and unpack something truly fascinating. We're looking at the ultimate statutory engine designed to protect our natural world, the National Green Tribunal Act of 2010. If you've ever wondered how environmental protection actually gets enforced on a national level without getting completely bogged down by years of backlog in traditional courts, well, you're absolutely in the right place. We're going to pop the hood on this incredible piece of legislation.
We'll break down this whole complex legal framework step by step. So, we'll start with the birth of the Green Tribunal, look at who actually runs the NGT, map out the specific green laws covered, explore their powers and guiding principles, and finally, wrap up with exactly how citizens can seek environmental justice. Section 1. The birth of the Green Tribunal, its origins and its purpose. Let's start right at the foundation. Think about this for a second. How does a country legally protect its citizens' right to a healthy environment? Honestly, it's a monumental challenge to balance rapid industrial development with essential ecology. And let's face it, traditional courts are usually swamped with every type of civil and criminal case imaginable. That means urgent environmental disasters can easily get stuck in a massive, multi-year backlog. Realizing this, India created a dedicated fast-track legal avenue to address this highly specific need. And the roots of this go back to a global stage. The NGT was actually born out of India's commitments at two major United Nations conferences, the Stockholm Conference in 1972 and the Rio de Janeiro Conference in 1992. Those historic gatherings called upon nations to provide effective access to judicial proceedings and give real redress to victims of pollution. India literally answered that call by enacting this 2010 legislation.
The absolute key takeaway here is that the NGT wasn't just created to be another court. It was designed from the ground up to be a fast-acting body dedicated exclusively to environmental preservation. The Act explicitly mandates the expeditious disposal of cases. It's all about delivering quick relief and compensation, rather than sitting back and letting environmental degradation just get worse and worse over years of drawn-out litigation.
Section 2. Who runs the NGT? Let's meet the architects of justice.
The Act mandates a pretty unique structure. It requires a minimum of 10 and a maximum of 20 full-time members, divided into two distinct categories, working alongside a full-time chairperson. This specific numbering ensures the tribunal is large enough to handle a heavy national workload, but focused enough to stay highly specialized. What's truly fascinating is the hybrid requirement to sit on this tribunal. It's proof that the NGT relies equally on elite legal minds and seasoned scientific experts. To be a judicial member, you literally have to be or have been a judge of the Supreme Court or a chief justice or judge of a high court. But on the flip side, the expert members, they need a master's or doctorate in physical sciences, engineering, or technology, paired with 15 years of practical experience, including 5 years directly in fields like pollution control or forest conservation. Or they need 15 years of top-tier administrative experience handling environmental matters. It is literally the perfect marriage of law and science.
Of course, behind the scenes, the tribunal needs a massive staff to function, from registrars down to scientific assistants. To make sure the quality of personnel remains top-notch, recruitment and promotions are tightly managed by a dedicated departmental promotion committee. This group includes the NGT chairperson, a judicial member, an expert member, and, importantly, the secretary from the Ministry of Environment, Forest, and Climate Change. It's an incredibly rigorous system.
To keep things accessible across a geographically massive country, the chairperson actually holds the administrative power to decide the tribunal's ordinary places of sitting and can move members around based on need. Plus, while cases are typically heard by a bench combining judicial and expert members, the rules note that the chairperson can authorize a single-member bench in exceptional circumstances. It's all designed so justice is never delayed just because of a logistical hurdle.
Section 3. The green laws covered. Let's map out their exact jurisdiction. The real power of the NGT comes from how it streamlined the system. Through strategic amendments, appeals that used to go to various scattered appellate authorities were funneled directly into the National Green Tribunal. It essentially centralized all this environmental jurisprudence under one roof with one expert body.
So, what exactly is in their toolkit? Schedule I of the NGT Act lays out the specific laws it oversees, and it is a comprehensive list. We're talking about the Water Act of 1974, the Water Cess Act of 1977, the Forest Conservation Act, the Air Pollution Act, the Massive Environment Protection Act of 1986, the Public Liability Insurance Act, and the Biological Diversity Act. Basically, if a substantial dispute pops up regarding the implementation of any of these 7 specific enactments, the NGT has the total authority to step in and settle the dispute. Section 4. Powers and Guiding Principles. Let's look at the tools of the tribunal.
Now, the NGT holds all the weighty powers of a civil court. They can summon witnesses, force the discovery of documents, take evidence on affidavits, the whole shebang. But here's the kicker. They aren't bogged down by the rigid standard code of civil procedure. Instead, they're explicitly guided by the principles of natural justice. This gives them incredible flexibility to act fast. And when they make a ruling, by majority decision, they have the power to mandate major relief, compensate victims, and order the actual restitution of damaged property and ecosystems.
Section 20 of the Act is absolutely crucial. It outlines 3 core principles that form the moral and legal compass for literally every decision the tribunal makes. First, sustainable development, which means balancing economic growth with ecological health. Second, the precautionary principle, meaning they can act to prevent harm even before there is absolute scientific certainty of a disaster. And third, the polluter pays principle. This one is exactly what it sounds like. If you damage the environment, the financial burden of restoring it and compensating victims falls entirely on you. No exceptions.
Section 5. Seeking environmental justice. Think of this as the user guide. Before the NGT can actually intervene, a dispute has to meet a very specific definition. It must be a substantial question relating to environment. This means an instance where community health or property is affected by a direct violation of a statutory environmental obligation. This rule is there to ensure the tribunal focuses its energy on grave, measurable environmental damage, rather than getting tied up in minor, localized disputes that don't involve those 7 laws we mentioned earlier.
But here is a real game changer, the legal concept of locus standi, or who has the right to file an application. The Act empowers any person aggrieved. It's incredibly broad. You don't necessarily have to be the sole property owner affected by a chemical spill to bring a case. This wide interpretation is absolutely vital for public interest litigation because it allows concerned citizens and organizations to actually step up and champion the environment on behalf of their community.
But listen, this justice operates on a very strict clock. If you want that fast action we've been talking about, you have to follow tight deadlines. Generally, you have just 6 months to file an application from the exact date the environmental cause of action first arose. If you're appealing a legal order made under one of those environmental laws, you usually have a tiny window of just 30 days. And if you want to challenge an NGT decision, you have 90 days to take your appeal directly to the Supreme Court. Knowing these ticking deadlines is absolutely crucial.
So, with this blueprint of the National Green Tribunal in hand, how might you use this knowledge to safeguard your local environment? The tools for environmental justice clearly exist within this 2010 framework. Between the elite legal minds, the scientific experts, the broad jurisdiction, and that rock-solid polluter pays principle, the NGT is a formidable guardian of our ecology. But remember, the engine only runs when an aggrieved citizen steps forward to turn the key. So keep your eyes open, stay observant of the world around you, and keep learning. I'll text you in the next explainer.